folks, and welcome back to Conveyancing. This is video 2 in the video series for subject matter of sale. And you will recall in the first video we had a little look at the identification of our subject matter. We also had a look at description of subject matter, and we ended up almost at the end of description of subject matter. We had a look at misdescriptions. We had a look at the way that these are handled in the REIQ contract, and now we need to look at material misdescriptions, and here we come to the rule in Flight and Booth. Now, this little test from 1834 has certainly stood the test of time, and the test is, and this test, mind you, is applicable to both misdescriptions as to property and also defects in title, to test the severity of either of those. If the buyer is not getting substantially what was bargained for, or, and the test puts it alternatively, putting it another way, if the buyer would not have contracted where they knew of the true position, then it would be a material misdescription, and the buyer is entitled to rescind the contract and avoid it altogether. A court of equity would not compel the purchaser to go ahead and settle the transaction by ordering specific performance. Section 69 of the Property Law Act simply acknowledges this whole position at general law, and if for some reason a contract precludes a buyer from objecting to title, then notwithstanding anything contained in the contract, if specific performance would not be enforced against the purchaser due to a defect in title, then they can get out of it under Section 69 of the Property Law Act. And as I said, that's notwithstanding anything that is expressly contained in the contract to the contrary, unless of course the actual defect is disclosed in the contract, for example. But that's Section 69 of the PLA that supports the general position under Flight and Booth. So where you have a misdescription as to the subject matter of your transaction and its material, then you can gain the assistance of clause 7.5 if it's an REIQ standard form contract. Otherwise, you have the general law test there for you. When will you lose your ability to object to misdescriptions? Well, obviously when you've actually gone ahead and accepted title. And when is title accepted by a buyer? Well, in the olden days, when requisitions were drawn up by the buyer's lawyers asking loads of questions about the property to try and get to the bottom of any potential misdescriptions or needed to know further information, at the end of all of that process really was only when the deed of conveyance was proffered by the seller and settlement could happen. Acceptance of title was then considered to have occurred either when the buyer possessed the property with knowledge about the defects in title, misdescriptions or so forth, or upon settlement. Now, obviously, under the REIQ, we are actually not able to deliver requisitions on title, and therefore objections to title can be maintained right up to acceptance, which is either settlement or possession or some other form of indication of acceptance by the buyer. And you'll note that in clause 8.5 of the REIQ standard form contract for houses and land, it says there, entry into possession does not waive the buyer's rights under the contract. So unlike the position at general law, where possession with knowledge is going to knock you out and you will have accepted title, here under the REIQ, yet again another buyer-friendly provision, possession won't be held to have caused you problems with objecting to title there. So that is acceptance of title. Now, when you've accepted title, I just want to flag for your refreshment of memory that you will have accepted the, if you've bought the fee simple, you will have accepted freehold land, which under Section 184 of the Land Title Act will be held free from all other interests. So there's no other bogeymen out there in the wings, except if the circumstances fit within one of the exceptions in 185 of the Land Titles Act, and you can probably sing them all along with me, follow the bouncing ball. But the big ticket items are equities arising from the act of the proprietor, the interest, that should be interest, of a lessee under a short lease, beneficiaries of an easement, even if it's been omitted or misdescribed on the register, adverse possessors, those naughty people that have somehow been inhabiting the property for 12 long years without being noticed, and proprietors with earlier indefeasible titles and so forth. That is what you'll be getting. The only other thing that you need to be thinking about in terms of descriptions of the subject matter are looking for things on title that will give you some inkling that there are problems afoot. And the text goes through the two main ones here: administrative advices and also unregistered and statutory encumbrances. Now, both of these we had a little look at when we were talking about seller's disclosure, so there's no real need to cover off either of those here. Suffice to say, you definitely do need to search outside the register. A register search is not going to be sufficient for what your client will need to know if they're the buyer. A last-minute check, obviously, of the register is mandatory, pretty much, whenever you're doing a conveyance. And the text does remind you that if, for some reason, the Land Titles Office computers are down, then the seller won't be in breach for failure of being able to prove title. Time will become not of the essence, and people will have to sort themselves out from there. So that is those two issues that I just wanted to flag for you. The only other issue here in terms of misdescriptions is compensation. So if a buyer's satisfied the test from the rule in Flight and Booth and they are not getting substantially what they've bargained for, then they will be entitled to compensation. Otherwise, if they fail that test, they will not get any compensation. Where a buyer is due for compensation, even if it is quite difficult for a court to calculate, they will give it a jolly good crack. And really, even though compensation is different to damages, very similar in terms of damages, just because it's difficult doesn't mean that the court is relieved from the exercise in trying to figure out some kind of remedy that will justly deal with the situation. Obviously, a court's exercise is going to be considerably easier if the price has been calculated by virtue of area, and the problem is something to do with the area. Then the compensation is going to be money payable for the deficiency in the area. If the misdescription is the lack of a physical attribute that was meant to be the subject of purchase, then the compensation will be payable for diminution in value of the land without that characteristic. The next question is a little bit more interesting. If the court has to decide between giving compensation for the cost of rectification, that is fixing the misdescription up, or giving compensation for diminution in value without the rectification, Edson and Son Quang Properties is the go-to authority there. In that case, you had an air conditioning unit and I think it was an electrical fuse box that were encroaching from a neighbour's property onto the property that was going to be purchased. And apparently the difference in price of the property with and without the encroaching overhangs into the airspace was about $350,000. Now, the court assessed the cost of rectification, that is taking down this offending fuse box and air conditioning unit, at around $15,000. In fact, there was some talk that it was actually quite a bit less than that, but the court said rectification would be around $15,000. Now, the court also made the astute observation there that where you're looking at the toss-up between whether you're going to give compensation for rectification or diminution in value, the difference between the property as it should be and the defective property can't be more than the total cost of rectification, because you can't have someone making a profit out of asking for compensation. So in fact, they didn't get their $350,000 diminution in value. They got the cost of what it would actually take to convince the neighbour to take this stuff down. Eminently sensible, but that's the issue of compensation there for where things have gone awry and there have been misdescriptions. So that is material misdescriptions, and that is the issue of misdescription of subject matter. So the next issue is defects affecting title. And I don't want to labour this really. We've discussed fairly fulsomely in our video series on seller disclosure all of the various defects that might affect title to which your buyer may object. Things like underground drains, services unlawfully passing through other land, notices by authorities or a court, and today errors and misdescriptions. They all go to title. However, there are other defective improvements and other issues, problems that do not affect title. Remember, we had a look at notices under the Building Act for owner improvements, non-licensed improvements. I will note that the text here does go into a discussion of the Sustainable Planning Act, and as I mentioned to you in the video series on seller disclosure, that has been repealed and we now have the Planning Act 2016 instead. So you can skip over pretty much any of the discussion that deals with the Sustainable Planning Act. But again, this is just a flag for your memory to see how everything all fits together. So another potential hazard that you need to be thinking about when you are thinking about the title that your buyer is going to get out of the transaction. The last thing we need to talk about is risk. Obviously, the all-important question is when exactly risk will pass and what risk passes. At general law, on execution of the contract, providing that it's obviously valid and legally binding, on execution of the contract, then risk will pass. Now, the seller will retain a legal interest, obviously, until the purchase monies are all paid over at settlement. Until that time, they have a trustee-like role. There you can see with the little yellow arrow there, the seller still has a duty to take reasonable care of the property, and the seller still does have some liability. They will be liable for any from neglect of their own or any damage by third parties that might enter the property and cause some willful damage. So essentially the seller will still be liable for losses that arise due to the action or inaction of them as the seller. However, the buyer assumes the very, very large risk of pretty much everything else. So they have, until settlement, a beneficial interest in the land, as we already know, because they can cave it. But the interest is commensurate with other relief that equity would provide, like specific performance or injunctions. And as I said, risk at general law passes on execution. Very significant difference here to the REIQ contract. The buyer will not assume risk until 5 p.m. on the first business day after the contract date. So if they're signing on Saturday morning, they are not going to be assuming risk until 5 p.m. on the Monday after they've signed. Like I said, very significant difference and significant window of opportunity for things to go wrong, and they won't be the buyer's problem, I guess. However, what we need to make sure of is that if you're ever acting for a buyer at this early stage, when you see the contract about to become binding, you really need to advise them with neon lights and red hands from Lord Denning and any other urgent tone in your voice that you can implore. They must insure the property from that time. In fact, the moment I signed my contract of purchase, I pretty much showed the real estate agent out of the door after signing and then got on the phone to the insurance company. So prudent buyers will always take this risk very seriously. If you don't, you really are left out in the cold, and there are a number of legislative half-baked solutions to the problem of a buyer being left with property that has been destroyed and damaged in between the date of contract and settlement. And the text goes into these at great length. I won't really expect you to know them in any detail, so mental note, you can just skim read that section, because really most of them are fairly ineffectual. Why is that? Well, firstly, because there's no duty on the seller to actually insure the property in the first place. So, you know, the buyer is not going to be able to rely on any insurance policy that the seller will have, because they may not have one. Even if they do have one, they're not obliged to keep paying, so the buyer can't rely on that either. The RERQ contract doesn't really clear this particular issue up because it doesn't mention insurance. So at all times the buyer must assure that the seller has no insurance and that they just get their own insurance. Like I said, there has been a number of different legislative runs at this to try and protect the buyer. So under Section 48 of the Insurance Contracts Act, a third party can actually go ahead and claim on an insured's policy if they are named as a beneficiary on the policy. You might remember from your contract law days that that provision in the Insurance Contracts Act was inserted there to overcome the rather unfortunate case of Trident. That'll pique your interest. Maybe go and refresh your notes there. However, as I said, you know, that's not going to help if the seller doesn't have an insurance policy, and they probably, the buyer probably most likely will not be mentioned in the policy as some kind of beneficiary. Then there's the possibility of Section 55 of the PLA, which you will recall allows third parties to enforce contractual promises made in their favour. That's contingent on a number of conditions, including the third party beneficiary accepting the benefit of the promise within a reasonable time. Well, that's not really going to work, because a seller's insurance policy, if they have one, will more than likely be well and truly formed. You know, and the time for acceptance of any benefit will have passed. Again, it's unlikely that there will be any mention of a potential seller in an insurance policy anyway. Under Section 58 of the PLA, this is where property is damaged by fire. Then there is a right to call for the application of the seller's insurance money to reinstate the premises. However, the big problem here is that once a settlement has occurred, then the seller will lose their insurable interest in the property, and the insurers will be released from their obligations. So I think the authors of the text rightly say there's certainly not much point trying to rely on that as a buyer, because it's not going to give you any certainty at all. There would be endless dispute about that and the insurable interest. What about Section 63 of the PLA? This attempts to modify the rights of the parties and basically says that the insurer is still going to be liable even though the risk of the property has passed to the buyer on completion, and that the insurer's consent's not required in terms of paying out the money to the incoming purchaser. The text just says that this particular provision is substantially flawed, and I'm not going to really waste our time here discussing it. You can flesh that out for yourself in the text if you want to find out the fine detail of that. Section 64 of the Property Law Act does allow rescission if there's damage before settlement that renders the dwelling house unfit for occupation. You might think, oh, that actually sounds like, you know, some reasonable remedy there. the only thing is, as you'll find out if you decide to have a wee look at this in the text, there's endless dispute capable around such gems as the phrase unfit for occupation and what will actually qualify as unfit for occupation, how much of the property has been destroyed and so forth. I mean, I guess this kind of thing might be useful if that was all you had to go on. But again, this is certainly not something that you would advise your clients to be relying on in terms of providing for the unhappy event of destruction of the property. Section 50 of the Insurance Contracts Act deems the buyer an insured. Again, I'll leave you to flesh that out in the text if you wish to have a wee look at the detail there. Out of all of this, I think the best advice obviously is for buyers to get insurance, and that is the issue of risk, and that is the topic of subject matter of sale. And as I always say, if you have any queries or questions, please don't hesitate to contact me. You know where I live, by email, by Teams, or you can catch up with me in a Zoom sometime. I hope we can chat soon. Other than that, thanks for watching, guys. Bye for now.